Thank you for coming back. And so I really appreciate your listening ears. In this episode, I will be going over the elements of your original petition for divorce. Now, don't panic. You probably and should have all of this information already. So to start out, you will need to make sure you have the jurisdictional right to file for divorce in Texas. You must have been a resident of the state of Texas for 6 months prior to filing for divorce and a resident of your current county or the county in which you are filing for divorce for 6 months. So 90 days in your county and 6 months in Texas. Now that you have those two boxes checked, we can go on. So you'll need your name, your full name, and you'll need the last 3 digits of your social security number and the last 3 digits of your Texas driver's license number. If you don't have those, then you can skip that part, but most of you will have that information. For most cases, the discovery level is level 2. Now, you will have to provide your soon-to-be ex with legal notice of this divorce. Now, divorce is a lawsuit, so you will have to provide your soon-to-be ex with legal notice of this lawsuit. If you think that they will sign a waiver of service, then you can, in your petition, note that you think they will sign a waiver of service. If you do not think they will sign a waiver of service, and this is a surprise to them, then you need to have them served. So you will have to request a citation, and you will have to have an address where they can be found. You may be able to serve them with a private process server or the sheriff's office. You'll have to note in your petition whether and that you meet those jurisdictional requirements. Now, there are a little few ways around that, but primarily you need to have lived in the county for 90 days, and you need to have been a resident of the state of Texas for 6 months prior. Now, if your spouse does not live in Texas or doesn't even live in the country, then you may have to employ the long arm jurisdictional rules through the long arm statute, and that is a lot of extra complexity that we won't really be going into today. You'll need your dates of marriage and dates of separation. The date of marriage is the date that you got married, and your date of separation, you can use the date that you felt like the marriage was over. Or if you had a big fight and you're like, nah, I'm finished, I'm out, that's it, that's your date of separation. In Texas, you don't have to have been living separately in order to use that date as a date of separation. It's the date that you felt the marriage was over. For the grounds of divorce, you can choose one of the fault-based grounds or the no fault-based grounds, which is insupportability. If you have children together, you must list out those children's names, their ages, their dates of birth, sometimes even their social, and the state in which the child currently lives. You'll need to note either at this time or later on in the case, before you go to any hearing, whether those children are covered under a health insurance plan. You'll need to note whether the children have any property of significance and whether there is another court order pertaining to the kids. Now, if there are children, again, you'll need to note whether you think you and your soon-to-be ex will work out a parenting plan or whether you want the court to make those decisions. You'll need to note what you want done with the passports, whether the children already have one, who has the right to apply for one, who has the right to maintain or renew the passport. So there's something called a standard possession order, which is often used in cases. You'll need to note whether you want to follow that, or if you have a customized plan, or if you want the court to decide that. In Texas, you cannot get a divorce granted while the wife is pregnant. So you'll have to note whether she is pregnant, and if she is, then the divorce cannot be finalized until after delivery. For family violence, it's really important to note whether there is a history of family violence. You'll need that to be in your petition. If you have police reports or other documentation of that, start gathering that because you will need it in your case. You'll need to note whether there are protective orders already issued or pending. Now it comes to your property. You'll need to note whether you have any separate property, which is property you owned prior to getting married, or property that is yours through gift or devise or some other legally defined way of it being separate property. In Texas, community property is generally all of the property, including assets, gained or acquired during your marriage. This includes the salaries of either or both parties who are working during the marriage. It includes your 401k plans, the vehicles purchased, your house, real property, pretty much any asset that you acquire during your marriage that is not separate property is community property. You want to summarize your petition at the end with what you're asking the court to do. What is your requested judgment? So those are the logistics as to what you put into that petition. But what you need to be working on in addition to those logistical things are your emotional things. Having someone to talk to about this, having someone to vent to, processing your feelings, processing the anger, the hurt, the grief, all of the emotions that you cycle through with the divorce. For free information online, please check out www.texaslawhelp.org. I am not a sponsor of that website. However, that is a very helpful website for people who want to read and download forms on their own. As a licensed attorney, I do not use those forms. However, those are free forms available for the general public.